I'll just wait for some folks to come back in and introduce our fireside chat. It's right in the middle of the day, and it's the sort of the conversation that hangs the day together. It's, where do the priorities of innovation and economic growth and diversity meet with intellectual property and competition goals? And we have the fireside chat with, really well-known IP folks who don't need much of an introduction, but I'm being tasked to do that anyway. So the chat is being moderated by David Kappos. He's here chatting with his panel. He's a partner at Cravath. He's a well-known IP personality. He has been a director of the US Patent Office in the past and worked at IBM and many other corporate jobs before that. And David, please welcome. And then we have Judge O'Malley. You all know Judge O'Malley. She doesn't need an introduction, but she was appointed to the U.S. Court of Appeals for the Federal Circuit by President Obama in 2010, and before that, she was a district court judge in the Northern District of Ohio, a longtime IP advocate too. Welcome, Judge O'Malley. And before that, of course, long private practice industry law experience. And Steve Suselka, he's CEO of the AUTM, the organization that manages tech transfer for universities, and a true PhD neuroscientist and a patent agent. Welcome, Steve. With that, David.
Okay. Well, thanks for joining this afternoon, Judge O'Malley, and can I call you Dr. Suselka?
Steve is fine.
Okay, Steve. So we're going to have a rather wide-ranging conversation here. There's just so much to talk about. We'll try and do some reflecting on what happened this morning, and we'll try and talk about the role of innovation and the role of tech transfer, since we've got someone from the tech transfer area. But just to start out on a very general question, I'd love Judge O'Malley to start out with any observations that you have from what you've heard this morning and generally about the role of intellectual property in promoting innovation. You heard a lot about that from a national defense perspective this morning, from other perspectives. How do you transit from innovation upstream to intellectual property causing or incenting that to happen in the first place?
Well, thanks, David. First, let me thank everybody for having me back again. I guess even in my civilian life, I got an invitation, so I was happy to see that came. And I want to say that there was so much said this morning, all of which was, I think, incredibly important, that I'm a little intimidated to follow those kinds of presentations. But as you know, David, you and I both have for years talked about the importance of IP to innovation, the importance of innovation to the economy. I think the shift to including national security in that has occurred only in more recent years, but it makes complete sense. As I said to someone earlier this morning, if you go all the way back to our founding fathers and you talk about Madison, I mean, he had this democratic view of innovation, and he felt that the best way to encourage even just the best and the brightest farmers and tradesmen to invent was to give everybody the right to have an exclusive right, which is what the patents are all about, and then to make sure that that exclusive right was one that they could enforce or license without having to have the wherewithal to practice their product. And Madison himself felt that one of the benefits to that it would not only be to make our nascent economy more wealthy, but to protect that economy from those that the country had just fought to escape from. And I think that it all has come full circle. We're starting to think about these same concepts. How do we incentivize innovation? You incentivize innovation by giving one the opportunity to benefit and to profit from that innovation. You incentivize, and you do that by intellectual property protection. I don't mean false intellectual property protection. I mean good, healthy, appropriate intellectual property protection. But I just don't I don't even understand the argument that somehow innovation would be incentivized on its own, and that people will innovate for the sake of innovation just because they like to think big thoughts. At some point, you need to encourage it. You need to provide the R&D, the money for the R&D that's necessary.
Yeah, I want to come back to the thinking big thoughts part for just a minute with Steve. But Judge Amal, you mentioned something that caught my attention, and it links to a really important comment this morning. One of the panelists this morning on the National Defense Panel mentioned the outsized role, now in my words, but I took it as the outsized role of small companies, of small entities in creating the breakthroughs that are part of our national defense then ecosystem. And that to me, speaks to your founding fathers comment. Just what from your role as a judge and life experience, just talk a little bit more about how the intellectual property system relates to the small entity, the little guy, in a way that's perhaps distinct from bigger companies.
Well, and, you're going to hear from Jonathan later, but as Jonathan's book points out, that once a company benefits from the use of IP and gets substantially large and gets big enough, they then don't need IP as much to protect themselves because they can use trade secrets, they can use their economies of scale. What you need the IP for is that next bright, different idea. And so that's why at some point you need to make sure that you don't throw the baby out with the bathwater and let big corporations who have already benefited from being the small, great idea people hurt the rest of us or the rest of the small inventors by just destroying our IP system.
Mm-hmm. Yeah, and so Steve, that brings me to the ultimate little guys, ironically, which are the universities, right? Which are hundreds and hundreds of great labs all over the country that are creating the innovations that save lives, that enable prosperity in so many ways. Talk about, just give us an overview of how this works in universities. You've actually done it, right? You were at Wake Forest for years, and now you run the organization that thinks about and advocates on behalf of university technology managers. Tell us from the ground level how this works and the benefits that it brings.
Sure, happy to do that. See how much time we have. So first of all, I want to thank Kirti and the organizers of this event. This is my first time here. Really robust and diverse discussion, which I think is fantastic. Unlike the judge, it's my first time. So let me quickly introduce Autumn. Autumn is a nonprofit association focused on supporting and advancing technology transfer. And although you may or may not know what technology transfer is, which is really the translation of that knowledge and research into impact to the society and to the economy, all of you have actually benefited from the advantages of technology transfer. So I'll give a couple of examples. Any of you that have allergies can thank, actually, I think Georgetown's here. Georgetown actually was the creator of the active ingredient in Allegra. If you've eaten a Honeycrisp apple, you could thank the University of Minnesota, nicotine patch, UCLA, and the list goes on and on and on. These are inventions that are actually developed often with taxpayer dollars, like us, that goes into research. That research takes place at nonprofit institutions such as universities or hospitals or research institutes. And then along the course of that research, inventions are developed. And in fact, I can give you a number. $3 million on average leads to an invention. So you could look at an institution that has about 300 million in research, probably gonna have about 100 inventions. Again, it's gonna differ depending on the type of the school and everything, but about that. So you have research that, or you have taxpaying dollars and other research funding that leads to research. That research along the way leads to inventions. Then what do? Now you have, at Georgetown, you have a new active ingredient that could be great to treat allergies. Well, Georgetown's not set up to create, do the drug discovery, all the packaging, the promotion, the marketing. They don't do any of that. So instead, we utilize technology transfer to then find a company that will advance that invention into the product and service of tomorrow. And that happens all the time. So just a couple of quick numbers, 27,000 inventions in 2020 alone. That led to about 10,000 deals. Each of those deals could be the next cure for cancer, the next photovoltaic, the next alternative energy or artificial intelligence product. So along this process, you've got inventions. They turn into products using this technology transfer. And what was interesting about Dave's question is the fact that, yes, sometimes these inventions go to large companies, but I'll tell you, 2/3 of the time, it doesn't. It goes to a small, to a startup, to a medium-sized company. And that is because of the risk inherent in those early stage inventions. Probably something we're going to get to a little later.
Yeah, so Steve, I just want to go a little deeper. Now you've linked in Judge O'Malley's comment going all the way back to Madison to the fact that what universities are really doing is acting as the R&D wings, if you will, for companies, large and small, but especially small companies.
Yeah.
You know, looking at the data, it's really quite staggering, like $1.7 trillion in U.S. GDP up to 2017. So that data is probably even a little bigger, a lot bigger now. 865 billion in gross domestic product. The first number was industrial output. 5.9 million jobs supported. So the numbers are just basically staggering. Talk a little bit about, where does that come from? I mean, what are the incentives that are required? I'm sort of going after the question I was going after with Judge Michel or with Judge O'Malley in a little different way. What kind of incentives are required for that to happen? Does it just happen because of curiosity, or what else is there that the capital sources are looking for that causes mind-blowing numbers like this across the economy?
Right. So that's a great question. And this does not happen by accident. This is due to investment, de-risking of that generally fairly risky technology initially, and a ton of hard work. So I can give you a perspective from my days. So we would receive an invention from an inventor who was focused 1,000% on that invention. Now, she might have been a wonderful inventor, but she is not, again, a CEO. She's not often a startup company person. So to advance that invention, we need to identify that partner that'll advance this. Again, this might be a startup company. This might be an existing company. What do we need to actually effectuate that transfer? And that's intellectual property. At that point, a university does not have Allegra all ready to go. It's got an idea that this is going to work, and we've got animal data that shows that it works. But that's about all we have. So a strong intellectual property system is absolutely critical for effective technology transfer. In the absence of that, these drugs, devices, all types of medical innovations, products, and services will just wither on the vine. There'll be a great paper, and that might be a great book, but it's not actually going to change society. So intellectual property is a key element and a key incentive. The other thing that's really necessary to drive this forward is the de-risking of that technology. It's investment into that technology. I've had a situation where I had a neurosurgeon sketch out a particular type of device. Said, this is going to work great. And I thought about it and I said, well, I can't really just file a patent on that and hope it works forward. Instead, what we did was we actually invested in a prototype of that invention. We actually were able to get some data, and now by de-risking, showing that invention is a little closer to market, we were able to attract companies that were interested in advancing that further.
Yeah, so Steve, let's just probe the other side of that equation for a minute. And I'll give an example that I'm only slightly generalizing here. I think it's in the city, Judge O'Malley, where your daughter is now living and working. A great medical institution that once it had a series of its patents invalidated, began moving its research funding and emphasis away from, in this case, diagnostics, biomedical diagnostics. And what I was told by the folks there when I visited was that whereas their scientists and researchers have the flexibility to choose the areas they will do upstream theoretical and basic research in, they find that those scientists elect away from areas where they know there's no hope for a company to eventually pick up a successful diagnostic and spend the $1 billion that it takes to move it into the marketplace. And so while we can have theoretical discussions about academic freedom and pursuit of curiosity and all that, the reality is that in the middle of the system, things will happen on the margins, of course, but in the middle of the system, if there isn't an opportunity to turn the great upstream innovation eventually into a product, the researchers will actually lose interest in it. They won't do the upstream.
It's not as much the researchers who are making that choice. I mean, the institution still needs to make money. So it's the institution has in place an entire system to teach the researchers where you can monetize these things. And so it's not really the researchers who say, I don't want to do diagnostics. They probably would want to. But given where the Supreme Court is with respect to diagnostics, the hospital system says, don't do it. Spend your money elsewhere. So yes, they have some freedom, but it's a guided freedom.
Exactly right. And Steve, any further observation on that from the university perspective?
Right, and so again, just put yourself in the shoes of those inventors. Those are researchers that spend their career, and a culmination of their career is not just a paper, but it's actually their research turns into a product or service. That might be something they're driving to. When they see that certain areas are just off limits because of court decisions or others, then they are not going to be as interested in going down that route, and they'll switch gears. And this happens all the time. So you're exactly right.
But the whole point about the small inventors and universities, that's why this troll dialogue was so unhealthy. It was all driven by some loud voices, and it completely misunderstood the whole concept of what our country and our IP system was all about. It was to do away with the requirement that you had to be the one who practiced the invention. And by creating this myth about trolls, you swept into that not just universities, but the small inventors, the Dean Kamens of the world, the ones who love to think big thoughts, love to come up with new ideas, but don't like the process of marketing them or manufacturing them. And so what you do is by disincentivizing them, by not giving them the ability to benefit from their IP, they won't come up with the next idea, because they'll feel like the only way they can ever make any money is to try to market or try to manufacture when they don't enjoy it. And so you end up, instead of moving the technology to the places where it fits best, instead of moving it to a manufacturing entity who enjoys it and is good at it, you then keep it with an inventor who then doesn't have time or the bandwidth to invent something else new. And it was such an unhealthy dialogue, but I mean, all the way up to Supreme Court cases where you can see certain justices on the Supreme Court buying into it. And they had no idea why they were buying into it. It was just so loud. And there was nothing to really support it.
Yeah. So
and I'll just note, a troll is a mythical being meant to scare people.
So to take the point, Judge O'Malley, from an economics level, I think of it as simple specialization. And we learned hundreds of years ago from economists that the opportunity for businesses to become specialized leads to, huge economic opportunity. And what you're really saying is this becomes a denial of specialization, forcing entities to do things they're not apt to do, they're not good at doing, they don't have the resources to do, and it doesn't end well for us.
Exactly.
Yeah. So, from there, I'd like to talk about a specific topic. I know, Judge O'Malley, this is something that's near and dear to you and probably to all three of us here and many people with us today, which is the exclusive right associated with patents. And it's come under odd attack in strange quarters recently, perhaps not so strange when the COVID pandemic started and you had the call for the TRIPS waiver, and here we are 2 years later, that's still banging around. And then more recently, you've had senators seeking march-in rights under the Bayh-Dole Act, and that we should talk about. Even more recently, just within the last few days, you've got the European Commission instituting an inquiry about compulsory licensing in Europe. And in the fine print, they mention standard essential patents as a reason they might want to have compulsory licensing in Europe. And I scratch my head when I hear about that. And then last but not least, in the context of the supply chain shortages with chips coming from Asia, you've got, again, calls for compulsory licensing as a way to deal with that, or setting aside patents, all just beyond strange to me. I wonder, start with you, Judge O'Malley. This has long been a topic you've been interested in. You can just comment on the importance of the exclusivity right associated with the patent, and whether any of these efforts to undo that make sense to you, or how we should think about them.
Well, I mean, there's a lot packed into that question because there's all different aspects and elements to it. I mean, it has always been true that even the right to an injunction is tempered by a public interest prong, and so that it depends on the level of the public interest. But it says it in the Constitution that there should be exclusive rights. It allowed Congress to set up a system for exclusive rights, and injunctive relief was always thought to be a part of that. I think the first problem was with eBay. Friends from around the world have told me that they think that was the beginning of the end for us being at the top of the food chain in terms of our IP system, that by the Supreme Court effectively discouraging permanent injunctions. Even at the end of the day, all they were doing was encouraging what some people refer to as effective infringement. Other people have not so nice words to describe it, but the concept being, if at the end of the day, the only threat that you have is to possibly pay the same royalty that you should have been paying from the very beginning, then what good is the IP protection? It makes it even more difficult to settle IP cases, because it used to be back in the day when I was in the district court, I'd say to one person, look, you could lose your patent, and I'd say to the other person, you could lose your business. And maybe they would find some middle ground. But now there's only one side of that equation, not the other side. And then when you put that things like the TRIPS waiver. I mean, I'm sorry, that makes absolutely no sense to me. It's not like we came. I mean, I've heard people actually say, look how fast they came up with vaccines. They didn't need IP to be innovated to do that, or to be incentivized to do that. No, it was about 16 years in the making. And it was because there was serial IP protections all the way along that it happened. There was also the ability to have companies feel comfortable doing joint ventures because they could protect their IPs from each other. So, I mean, things like the TRIPS waiver make no sense. The Bayh-Dole argument is march-in is just a warping of that statute. It was never intended, as someone said this morning, to work like that. So I don't know why there is such a move away from allowing exclusive rights to actually be exclusionary, at least to an extent. I mean, obviously there are times when someone's not practicing the patent at all and doesn't have any intention of practicing the patent and is not earning money from having licensed the patent to a practicing entity. You can see why the balancing of factors would say maybe not. Or there be a system, a point where if the chips shortage was so dramatic that in that case, you might say the public interest outweighs the exclusive right. And that's just the normal application of injunctive relief law. But you can't just say, because we as the public don't feel like you should be allowed to make money from your products. I mean, someone mentioned it this morning. You can't say just because I want free medicine that I'm going to say that will take away any ability to profit from it, because otherwise you're not going to have medicine in the long run. So yes, there might be those guys in the garage who are going to always come up with a new great gaming system, whether they're incentivized to do it or not. That's not applicable across the economy.
Mm-hmm. Yeah, the big innovation, the expensive stuff, the hard stuff, it just won't happen. Well, Steve, you've got to feel strongly about this Bayh-Dole Act margin right point, so please comment on that.
Very much so. And again, how much time do we have here? But I will be brief on this one. So we talked about the Bayh-Dole Act before, passed in 1980. It revolutionized American innovation. And I'm saying this as the CEO of Autumn, but I would say this as anybody. It has changed the landscape. It was mentioned earlier that law has been passed over and over in countries around the globe because of its effectiveness. Now, when that was passed in 1980, and we started talking about it briefly earlier, when it was passed in 1980, there really weren't very many university tech transfer offices. There was no need to have them back then. Most inventions were federally funded and therefore owned by the federal government. Federal government was responsible for commercializing them. And maybe not all that effectively then. Bayh-Dole Act happened. That, for those of you that might not know, allowed the inventing institution to retain the rights to an invention developed on their campus, and then they were able to license that intellectual property to someone who would drive that forward. So that's what the Bayh-Dole Act did. It had provisions back to the government, since the government did fund in part or in whole. One of the provisions was this idea of march-in. And the idea was, if the university did a poor job of licensing, so I will license my intellectual property, but you're going to give me $6 billion every time you sell one, that's an unreasonable term. And so that has now been warped into using march-in to take back intellectual property that was actually commercialized properly and not in violation of Bayh-Dole at all. And in fact, Birch Bayh and Bob Dole both came out with an op-ed saying exactly that march-in rights are meant for certain things, and this is not one of them.
The irony of it all is that Bayh-Dole meant to incentivize public-private partnerships, because the government realized that it could not do as much with all of its inventions as it should and as our economy needed. And so it allowed these partnerships. And so now what we're saying is we're going to use Bayh-Dole to basically shut down the private side. So it's no longer a partnership, it's we're going to dictate to you instead of saying we're going to do this as a team. And so that's why it's really problematic.
And if I could mention something else, earlier we talked about, I think it was Ambassador Schwab mentioning unpredictability. So that's just, we're going to be in a perpetual state of that. Technology transfer is all about unpredictability. You want to minimize the risk. And so you minimize the risk by developing the prototype to show it works. You minimize the risk by having strong and predictable intellectual property. You do all these things to actually make that more attractive for a company to develop further, which costs a lot of time, money, and other aspects. So you want to reduce predictability, you want to reduce unpredictability and make it more predictable. March-in, an inappropriate use of march-in, does exactly that. It makes it completely unpredictable. The first time march-in is used inappropriately, that will cause companies to all of a sudden pause and say, do I really want to license federally funded inventions that could be yanked, carpet yanked below my feet because someone's inappropriately looking at march-in rights again? That used to happen. Again, prior to the Bayh-Dole Act, there was a phrase that companies used, and it was contaminated by federal funding. If an invention was funded by the federal government, again, owned by the federal government, companies just stood clear. I do not want that unpredictability.
Right.
That's the way you're moving back
And
to.
if you use
potentially.
margin rights for whatever the given policy position of the given administration is, and imagine what that means, because you never know when those policy decisions or policy motives are going to change. And so today you might want free medicine. Tomorrow maybe you're going to say, well, we don't really care about climate change anymore. So we're going to basically say, whatever you've done, just give it away and move on to something else. You could change the policy positions and use those margin rights to warp anything. I mean, right now it's all focused at pharma, which people, I just don't understand the notion that they think it's really that easy to come up with medicine. I mean, for every one that is a success, there's a whole host of others that never see the light of day, and all of that costs money, and all of the R&D costs money, and all the regulation adds money. So that the notion that you would just choose to use that margin right for any particular policy purpose at a particular time is extraordinarily dangerous, actually.
Yeah, it's a major slippery slope issue, and it sets precedent. Same thing with the TRIPS waiver when that started, right? If we go down that road, it sets precedent that you really can't take back. So it's very dangerous. Just to put a bookend on this part of the discussion, I reflect back on one of the earlier panels where there was a comment about what the Ukraine crisis has taught us about the desirability of radical transparency to get facts out. I feel like if there were well, put it a little differently, I don't think we need radical transparency on this issue because I think we already have it. Those who benefit from being able to infringe patents with impunity, because of the point you were making, Judge O'Malley, that in the end, they will suffer no worse fate than taking the license that they could have paid to take up front. And therefore, they've been quite transparent in saying it would be malpractice for us to advise our clients to take a license without forcing patent holders to litigate first. So we already have radical transparency. We know how this goes, and we're living in what results from an exclusive regime that is robbed of its exclusivity.
Yeah. I want to make one point about Ukraine, and it's because I had the privilege to be asked by the Queen's College of London to do a program that was designed to create an IP court for Ukraine. And it was there were several judges from the UK and then a couple other scientists that were involved in coming up with this court system, or helping to design a court system and to do the training for the judges. And when I asked why the Ukraine, why are we picking this country? And they said because the amount of innovation that was coming out of Ukraine was so surprising, and it was so great that they wanted to make sure that innovation was protected. So that rung home to me when someone mentioned that we should allow the everyone to enter the country, and we should allow them to innovate to our benefit. And I hope that we get some of those people from the Ukraine that were the small innovators that were coming up with the good ideas, because you never know where it's going to come from.
Yeah, well, that, in my mind, that bridges a bit to this pending legislation, and I know this is another topic, Steve, that's near and dear to you, is the USICA and the concept of having a new focus, a new impetus, and really massive funding for tech transfer. Talk a bit about what's going on with that. That's sort of been moving around in the bowels of Congress right now. So I'd just like to make sure everyone's aware of where it stands.
Sure. So from my perspective, this is the most important piece of legislation for tech transfer since the Bayh-Dole Act, since 1980. And so for those of you that might not be familiar, there are two different, there's a House and a Senate bill. The Senate bill, USICA, United States Innovation Competition Act, has a provision in there, Section 2109, that actually invests in technology transfer. So Dave mentioned some of the amazing output of technology transfer. That is actually done by the university just funding patent costs on their own, funding the hiring of talented tech transfer staff, hiring incubators and ways to de-risk those technologies. It's all been done sort of, finding money in the couch cushions. Now what you're talking about is the federal government is actually investing in technology transfer at a level never done before. And before we were talking about CBERs or SBIRs and that importance of investing in intellectual property. This legislation, in my view, 2109, will actually accelerate the development of the next generation of products and services. In addition to that part, another aspect of this section 2109, so there's investment in the tech transfer. There's also investment in community building, and so community innovation research centers. And so the idea there is, and it was mentioned by Judge O'Malley, innovation happens everywhere. It's just not captured everywhere. And so a community innovation research center allows innovations across that region, even though they might not be at a large institution, to actually be advanced. It's a huge step forward as well.
Which is why funding for NIH is always critical to me. People say, oh, well, just because people want to go be treated by NIH? I said, no.
They're way upstream.
You don't understand how important NIH is in terms of their development of technology and what they give to the economy in the long run.
Yeah, now, so long as the Bayh-Dole Act is left as it is, and we don't get margin rights, NIH can continue to play a huge role, right, in university research and tech transfer also. So I want to bridge for a moment to one of the panels that we had this morning. Again, the National Security Panel, there was a very interesting point made in the context of biotech, AI, and materials industries. And the way the point was framed was that those are enabling technologies. I would add 5G to that also, and we could call them roughly enabling technologies or platform technologies in that they enable, create ecosystem opportunities, and many things get built on top of them, right? The food delivery industry, autonomous vehicles, being able to get from anywhere to anywhere using your smartphone, all the various great innovations and business models we have that were built on these platforms. And you could say the same about artificial intelligence and biotech. My question is, it feels like those very areas, biotech, AI, 5G, materials, in many ways are the ones that are being the most challenged as to patent protection, whether it is under the eligibility laws, this invention is too abstract or whatever, so we're not going to permit its patenting in the first place, or this invention isn't described well enough according to some I would say unclear standard, therefore we're not going to permit its patenting. But it feels like there's something going on here when you have national security experts pointing to technologies as being super critical to our national security. Of course, that's what they're talking about. And again, I include 5G in this category. On the one hand, but the rest of the government, legislative branch, the judiciary, our basic legal system, saying we're going to put more pressure on these platform technologies and we're not going to enable them, we're not going to permit them to be protected for various reasons. And I think it all boils down to the fact that they are platforms, they are enabling, and there's so much that gets built on top of them. So I just wondered if you could comment on whether you feel like some innate discrimination is coming about on that basis, all well-meaning.
No, I'm not sure I would say innate discrimination, but I think it's true that there are those on the courts and in Congress and in the administration who are less inclined to believe that IP does enhance innovation. And I think that there is a view that if you weaken IP for those very enabling innovations, then it'll be more broadly available to everyone. And then everyone can innovate on top of that on an equal basis. Do I agree with that? No, I don't. But I think that's the rationale, and that's what the concern is, and that's why when you hear that from the National Security Panel, they're saying that's not a wise approach, but it is the approach that I think is being followed in a lot of areas of our government.
And you think it comes down to perhaps a view on the part of courts, legislators, that this technology is so core, it's kind of like scientific principles in their mind, something like that going on?
Well, and of course it's strange because what is a core scientific principle changes from day to day. So that means that in the future we're going to say that some of these core scientific principles that really had to grow from innovation, that they're going to become so core that they're no longer entitled to protection. It's a slippery slope, as you said before. But I do think that's part of it. I also think that there are just, this for sure at the Supreme Court was true for years, but there are some people on the Supreme Court, some justices on the Supreme Court, who I think believe that IP protection, period, is problematic, and have always feared monopolies more than they want to protect IP. And so they view IP as not really a legitimate monopoly. They know it's one that they're supposed to be stuck with, but they don't want to be stuck with it. And I think that many of the decisions that came out of the Supreme Court in the last 10 years, I think can be attributed to that attitude.
Sounds like the cocktail hour. We can try and get you to name names. Steve, at universities, you guys are doing the upstream research. How could this make sense that we're saying, we don't want the most important foundational stuff to be incented?
Right. And I think nonprofit institutions like those universities, hospitals, research institutes, they're on the bleeding edge of this. They're the ones that are developing the technologies now that'll be the companies 20 years from now. They're the ones developing that. And you can either smother that in the crib, or you can actually incentivize that to actually be advanced. And a great example is CRISPR, right? So CRISPR was identified, a gene editing technology, and they looked around and said, all right, what gene editing companies would like to license this? Well, the answer is none, because there are none. So what happened, we actually created startup companies across the country focused on gene editing. And now you're using it for agricultural purposes, others. The only reason that went forward at all was the ability to actually protect that intellectual property and provide an incentive to actually allow investment into that. And I think it was Judge Michel who said the patent system is really designed to support not just inventors, but investors. And from the technology transfer standpoint, that's exactly right. If we can't find an investor that's willing to put in the capital needed to bring these products to market, they'll just wither on the vine.
Yeah, clearly a ways to go. Well, that actually brings me to a topic regarding the current administration. And we know that the current administration has made a point, as many administrations do, that they want to incent small business, small entities, small inventors to prosper. I wonder if you could both just talk a bit about what the administration needs to do that, where they need to do, to be a little more pointed, where they need to do more and where they need to do less. My observation is there's some things they're doing right now that absolutely are not aligned well with that objective. And if they really do want to pursue that objective, some change is needed in approach. But I'd love to hear your views.
Well, clearly there is concern, I think, with the fact that as was said earlier this morning, that that this administration is intent on using what they call in Europe competition law or antitrust law to basically dictate what corporations can do and how they can grow and whether they can advance. And I don't think it's healthy. I think it has done, when you look at other countries, yes, they have a competition law principle, but it's never been enforced in a way to say that just because you're successful, then by definition, we've got a problem. And, or just because you've got a joint venture agreement, then by definition, there's a problem. And so I think, to me, the number one concern I have is the extent to which, and here's the problem, if you're a company, there are about 5 different entities that could come at you with competition law concerns. And you never know which one is going to decide to target you. And so I think that is one of the biggest problems with this administration. That said 4, but whatever.
Yeah. And as each of you know, we're talking about a monopoly, but it's a limited term monopoly. And so if I take this round to the beginning where we started with Allegra, Allegra's a great example. That was an invention developed at Georgetown, hometown hero. They developed this compound. They were able to secure intellectual property rights that allowed them to license it to a company that now makes it for the benefit of us all. The original patents are off patent. You could go to CVS and get this phenoxyphetidine for pennies now. So the system works. But if you don't actually allow it to actually mature that way, nothing would have ever existed. But that's true. I think a lot of people, and this goes to the education point, I think a lot of people don't understand that the patent monopoly is a limited monopoly and that there's a return. Yes. You have to disclose your invention in the patent so that other people can then improve on it going forward. And so it's not just, oh, you get this monopoly because you want it, but you get this monopoly for a limited period of time in return for full disclosure. Yeah, that's exactly right. Salicylic acid, that's aspirin. That used to be patented. Of course, we all use it. We all have the benefit of that. So that's one example. But back to your question about what can we do to help accelerate innovation? So again, Section 2109 of USICA, I think, is a huge step forward. Another is just creating a stronger and more predictable patent system. If that doesn't happen, there's so much more unpredictability that will just, again, slow down the process of innovation. I think that's really important as well.
Yeah, so those are some good examples of both things to stop doing, get the antitrust laws out of the way, make them the exception and not the rule, and things to do.
But 2 points from this morning that I completely agree with, and I'm sure we all will, but the one is we need a more centralized, unified patent policy instead of it coming from all different arrays. Mm-hmm. The other is we need education. We need to educate the public about the importance of patents to the economy, to security. We need to reach down and starting all the way with bringing more people into STEM education. And the education shouldn't be just, we want you to like math. We want you to like math because we want you to innovate and we want you to understand why patents are important to that process.
So classic role the government could play on the positive side, yeah. So just in view of the time, thought let's end on a sort of an up-level point on this antitrust topic for a minute. You might remember Rob Atkinson this morning made a point of mentioning Schumpeter, Joseph Schumpeter, and I'll paraphrase his approach of dynamic competition having sway over static competition. Static competition, of course, is competition on today's products and services. Dynamic competition is the idea of creating new products and services that create new competitive opportunities. We've all been around antitrust issues our whole career. Have you ever heard of the antitrust authorities, really talking about tools or approaches or methodologies or respect for dynamic competition, the competition that's enabled by a strong patent system?
I've heard academics talk about it, but not the actual antitrust authorities. They don't think it's their job. They don't think that that's their role, and I think it's short-sighted.
Yeah, so maybe that's a concrete opportunity for the government to end with, is a formal focus on Schumpeterian-based antitrust competition. So with that, I realize we're now out of time. So let me just end by asking everyone to thank Judge O'Malley and Steve Chicago. Great.